At exactly 10 a.m. this morning, the final door closed. For months, the American public has watched a slow and deliberate legal process unfold. There were filings stacked on top of filings. Appeals layered carefully over earlier appeals. Procedural motions designed not to confront evidence, but to delay the moment when evidence would finally be tested in a courtroom. It has been exhausting to watch. It has been frustrating. And for many Americans, it felt intentional. The wheels of justice appeared to be turning, but never quite moving forward. Each time accountability seemed close, another legal maneuver emerged. Another pause. Another delay. Another argument asking the system to wait just a little longer. Today, that waiting ended. This morning, the Supreme Court of the United States issued a definitive order. It was not accompanied by dramatic language. It did not come with a lengthy written opinion. It did not need to. The court terminated the stay. That phrase may sound technical, but its meaning is profound. In the legal world, this action is known as the issuance of mandate. It is one of the most powerful procedural moments in the American justice system. This is not a theory. This is not commentary. This is not speculation. This is a binding legal directive. The issuance of mandate is the formal notification that the work of the higher court is complete. The Supreme Court has finished its review. Its authority over the case has ended. Jurisdiction has now returned to the lower court where the case originated. In plain language, the Supreme Court is done. The delays are over. The law is free to move forward. This mandate functions as the legal equivalent of a green light. It authorizes the special counsel and the district court to proceed without further interference. No additional appeals. No procedural freezes. No hidden escape routes. For prosecutors, this is the moment every long case builds toward. I have spent decades building cases, and I can tell you with certainty, this is the moment the law is finally permitted to take its course. It is the moment when arguments end and accountability begins. And this moment carries with it a specific 48-hour procedural window that has now been triggered. The clock is ticking. To fully understand the gravity of what happened this morning, you have to look back at the pattern that brought us here. This did not happen overnight. This was not sudden. This was not unexpected. In June, the defense filed a motion claiming absolute immunity. The argument was sweeping in scope and dangerous in implication. It suggested that a president, by virtue of holding office, could not be prosecuted for criminal conduct connected to official acts. The district court rejected that claim. In August, the defense escalated the same argument to the appeals court. They were no longer asking simply for dismissal. They were asking for a precedent that would permanently shield future presidents from criminal accountability. Once again, the answer was no. The third attempt was the final appeal to the Supreme Court. This was not merely another legal filing. It was the last line of defense. The final procedural barrier standing between delay and consequence. And it is important to be honest about what this appeal was designed to accomplish. They were not seeking clarity. They were not seeking justice. They were seeking time. Every filing followed the same strategic objective: push the trial date beyond the election. Prevent a jury of American citizens from hearing evidence before voters made their decision. Prosecutors are trained to identify patterns, and this pattern is unmistakable. It demonstrates intent. It reveals strategy. And today, that strategy failed. The court record is public. Anyone can read it. The filings show a defense team gradually running out of legal road. One of their central claims was that a president must be impeached before being prosecuted. That claim has no grounding in constitutional law. Today, the Supreme Court ended that argument permanently. The rejection was not emotional. It was not political. It was procedural and precise. The court did not merely deny review. It allowed the mandate to issue immediately. That distinction matters. When a mandate is issued, it formally dissolves the stay that has been holding the lower court case in suspension. Think of it as a dam that has been holding back pressure for months. Once released, the process resumes with force. The case now returns to the district court, the court where the arrest warrant originated. The delay tactics have reached a dead end. You may hear commentators mention this phrase repeatedly today, but few will explain what it actually means. So let's break it down in plain English. Inside the judicial system, it is called a procedural mandate. Outside the courtroom, it is a green light. When the Supreme Court rejects a final appeal, it does not simply move on. There is a formal, structured communication between the Supreme Court clerk and the district court. Once that mandate is received, the stay is dissolved. Jurisdiction is restored. The lower court regains full authority. Judge Chutkan now has the power to reinstate the trial calendar immediately. More importantly, she can authorize the execution of pending orders. This includes the processing of the arrest warrant. This is not speculation. This is procedure. The U.S. Marshals and the Secret Service have already been coordinating behind the scenes. They do not wait for headlines. They wait for paperwork. Once the 48-hour administrative window closes and the mandate is docketed, the warrant becomes active. This brief administrative lag is not hesitation. It is the system working exactly as designed. It ensures that when the law moves, it moves with absolute procedural integrity. This is the final chapter of a year-long delay. The next phase of this process is not measured in weeks or months. It is measured in hours. Once the Supreme Court issues its mandate, there is a short administrative window. This window exists for one reason only: to allow lower courts and federal agencies to synchronize their actions. It is not a delay. It is coordination. Inside this window, several things happen quietly and efficiently. Court clerks docket the mandate. Judges receive formal notice. Law enforcement agencies receive confirmation that jurisdiction has returned. This is where reality begins to set in. When people hear 48 hours, they often imagine negotiation or discretion. That is not how this works. There is no debate happening behind closed doors. There are no political calculations being made. There are checklists. And once those checklists are completed, the system moves forward. The arrest warrant in this case was never cancelled. It was never withdrawn. It was simply paused. That pause has now been lifted. From a procedural standpoint, this case has snapped back into motion exactly where it left off. No resets. No do-overs. No fresh delays. This is not just another court loss. This is the collapse of the last viable shield. Earlier losses could be spun as temporary setbacks. Appeals courts could be framed as stepping stones to something higher. Supreme Court review was the ultimate hope. Once that door closes, there is nowhere else to go. There is no higher court. There is no emergency motion left. There is no procedural escape hatch. From this point forward, any attempt to delay proceedings would require extraordinary circumstances. And those circumstances simply do not exist here. That is why today feels different. That is why seasoned prosecutors and defense attorneys alike understand the weight of this moment. This is the end of procedural maneuvering. It is important to understand the defense strategy because it explains why this moment matters so much. The defense was never built around winning at trial. It was built around never reaching trial. Every filing served the same purpose: push accountability past a political deadline. Delay until voters decided first. Create confusion. Create exhaustion. Create doubt. This strategy is not uncommon in high-profile cases. It is especially common when evidence is strong and timelines are dangerous. But delay strategies have a shelf life. Courts tolerate them only so long. Eventually, judges begin to see patterns. Appeals courts begin to recognize repetition. And higher courts begin to reject arguments that lack legal foundation. That is exactly what happened here. The Supreme Court did not issue a dramatic rebuke. It did not need to. Silence, in this context, was louder than any opinion. The denial speaks volumes. With jurisdiction restored, the district court resumes full control over the case. This includes reinstating the trial calendar, enforcing existing orders, activating previously authorized warrants, managing pretrial logistics. Judge Chutkan is not starting from scratch. Her court is already deeply familiar with this case. She has ruled on motions. She has reviewed filings. She has prepared for trial. The machinery is already built. All that was missing was permission to proceed. That permission arrived this morning. Once the arrest warrant is executed, the process follows a well-established federal path. There is no improvisation here. Every step is governed by rules that have existed for decades. The defendant is processed. The court appearance is scheduled. Conditions are addressed. This is routine for federal courts, even when the defendant is anything but ordinary. A great deal of speculation surrounds the role of law enforcement in moments like this. So let's be clear. Federal law enforcement does not act on headlines. They do not act on speculation. They act on authority. That authority has now been restored. The coordination between agencies has been ongoing for months. Plans are in place. Contingencies are mapped. Security protocols have been reviewed repeatedly. This is not reactive. It is prepared. The existence of a Secret Service detail does not negate the authority of a lawful warrant. It simply changes the logistics of execution. Those logistics have already been addressed internally. This is not unprecedented. It is not unmanageable. It is not chaotic. It is procedural. This is not commentary. This is not punditry. This is not cable news theater. This is the criminal justice system operating in real time. Too often, political coverage turns legal proceedings into entertainment. Arguments are framed as wins or losses rather than steps in a process. Viewers are conditioned to expect twists and reversals. But real law is not dramatic. It is patient. It is methodical. And when it finally moves, it moves decisively. That is what we are seeing now. This case has reached a point where momentum favors action, not argument. There is a reason this moment is being watched so closely around the world. At stake is not just one defendant. At stake is the principle that no individual is above the law. That principle is easy to recite. It is far harder to enforce. Enforcement requires institutions willing to withstand pressure. It requires judges willing to rule based on law rather than politics. It requires courts willing to say no when powerful interests demand exceptions. Today's mandate is not loud, but it is firm. It affirms a core principle: the presidency does not grant criminal immunity. That precedent will matter long after this case ends. The next days are critical, not because something unexpected will occur, but because something inevitable will. The administrative window will close. The mandate will be docketed. The warrant will become active. At that point, theory ends. The process becomes real, and the narrative shifts permanently. In cases like this, there is a clear dividing line. Before the mandate, everything is speculative. After the mandate, everything is procedural. That line has been crossed. From now on, there are no ifs, only timelines. The legal system does not rush, but it does not hesitate once authority is restored. That balance is its power. Nothing happening next is personal, emotional, or improvised. It is administrative law functioning as designed. Many assume drama will dictate events, but the reality is quieter and far more consequential. Paperwork moves. Orders are transmitted. Officers receive instructions. What once felt abstract becomes unavoidable. High-profile defendants are often assumed to escape at the last moment, through surprise injunctions, emergency rulings, or political intervention. This is a myth. Emergency relief requires new facts, evidence, and immediate harm. None exist here. Every argument has been heard. Every procedural claim reviewed. The Supreme Court's refusal to intervene signals that nothing justifies further delay. Legal experts are no longer asking whether something will happen. They are asking how it will happen. The return of jurisdiction places full authority in the hands of the district court. Trial courts do not speculate or issue advisory opinions, they enforce. Judge Chutkan now has discretion to move forward, set deadlines, enforce compliance, and preserve procedural integrity. Her prior rulings show she does not indulge delay tactics. She emphasizes the public's interest in a timely resolution. The term, arrest warrant, triggers dramatic images, but federal warrants are executed carefully, in coordination with legal counsel, in controlled environments, with layered security. This is not a surprise knock. It is a managed transition from freedom to custody. The goal is not punishment but compliance. Once custody is established, the process continues uninterrupted. Public messaging often diverges from legal reality. Statements will be made, narratives framed, supporters and critics will claim vindication. None of that changes courtroom proceedings. Courts respond to filings and law, not public opinion. The case has moved beyond messaging. The Supreme Court declined to intervene. Everything unfolds according to rules, not rhetoric. Many assume the next phase will be slow. That is incorrect. Delay occurred only because higher courts were involved. Once appellate review ends, the pace accelerates. Trial courts operate on schedules. Deadlines matter. Noncompliance has consequences. With jurisdiction restored, the court is incentivized to move efficiently. Extended delays undermine confidence and strain resources. Experienced observers expect rapid developments, not chaos, not spectacle, but movement. This case is under international scrutiny. How a democracy enforces accountability at the highest level sends a global message. Equal justice applied evenly reinforces democratic norms. Failing to do so weakens them. This moment will be studied for years, not for the defendant, but for the system's response. Amid legal analysis, it is easy to forget the people involved: judges maintaining fairness under scrutiny, court staff executing duties flawlessly, law enforcement following orders without discretion. Their professionalism prevents instability, and it has held. There is no rewind. Once jurisdiction returned, the clock restarted. The implications go beyond one individual. This case clarifies boundaries, establishes that power has limits, and affirms the Constitution. Future leaders will study this, not to fear, but to understand. Ultimately, the process leads to one place: a jury box. 12 citizens, no titles, no immunity. They decide based on evidence under court rules. This is the most democratic element: people, not judges or politicians. Now, the process is predictable. Noise fades, speculation quiets, facts dominate. Trials are intentionally constrained: testimony, documents, and law. This environment is hostile to misinformation. Years from now, this moment will be remembered not for headlines, but for restraint, for institutions following procedure, and for democracy functioning under stress. We have moved from speculation to execution. Arguments are done. Jurisdiction is settled. The process is active. Everything following is governed by law, not opinion. This is democracy in action. The Supreme Court has spoken. The stay is gone. The mandate is active. The clock is running. What comes next is law, not discretion. The lower court holds authority, administrative steps are in motion, and accountability is unavoidable. This is about the rule of law, limits of power, and the foundation of democracy. Every motion exhausted, every argument considered, the system has held. The trial will proceed. Facts will decide. Justice is moving as it was always meant to. No one is above the law, not today, not ever. This is the power of the Constitution in action.